gives me a lot of pleasure to welcome Eric Jonsgaard here. We have worked with First Fiduciary for years, and we hold them in high esteem. So I'm eager to hear what he has to say. He's going to be speaking to us about wills and trusts and power of attorney, how to protect our assets. So would you please help me give a warm welcome to Eric Jonsgaard.
Thank you. I'll give you a little, I neglected to send in my bio for an introduction, so I'll give you a little bit of an introduction myself. My name is Eric Jonsgaard. I'm currently the Vice President of Operations at First Fiduciary Corporation. I've been doing this work with First Fiduciary since 2011. And prior to that, I was the statewide director of Guardian Conservatorship and Trust Services at Lutheran Social Service. So I'm actually going on, 14 years of doing fiduciary work in these sorts of services. So today, I want to be clear, I'm here in my capacity as serving as a fiduciary, in my role as power of attorney, as PR of the estate, trustee, conservator. I'm not an attorney. We work with plenty of attorneys. If you need legal advice or you're looking to actually set up your estate plan, my contact information is in there. So I can definitely refer you to someone. If you hear something today and you say, I'd like to get that set up, please let me know. So today we'll be talking about a couple of things. I just hold this. Strategies in protecting your assets. So, a lot of times I'll have folks come into our office who are going to name us in the estate plan. And we're talking about what they're going to do when they die. And then we get through it, and it's usually they've only had the initial conversation with the attorney. The attorney says, you might want to consider a neutral party because they may not have family. They may not have family who can or should follow through with their estate plans. So they'll say, go out and talk to First Fiduciary. We get to the point where I say, well, what happens if you become incapacitated? And I get this look like, I suppose we need someone in that case too. The point being they're coming in to really talk about what happens when they die, and then we spend most of the time talking about what happens when you need a little help or a lot of help while you're still alive. So that'll be strategies in kind of protecting your assets. We'll talk about the estate, wills and trusts and those sorts of things. Choosing the right person or organization to assist you or your loved one. What might be a good fit for you and your individual capacity. And then if we have time, we may talk a little bit about strategies in protecting medical and care decisions. I do have information in your packet about those services, healthcare agent, care management, and guardianship, but we probably won't get to that today. So when we're talking about strategies in protecting your assets, again, this is while you are alive. What can you do while you're alive to make sure if something happens to you, there's someone in place who can pay your bills, keep you eligible for benefits, go through your Part D or your supplemental plan every year to make sure you're still on the most appropriate plan, those sorts of things. And these things can be done in a number of ways. Informal management of assets, which we'll talk about a little bit. Power of attorney, what that means, what it doesn't mean. Trust. If all else fails, conservatorship, which you're trying to avoid at all costs. And then representative payee, a very specific program. So when we're talking about informal management of the estate, this is usually something you would be doing with a family member, obviously your spouse. It's a pretty easy thing to do. You set up your bank auto pays. You have joint bank accounts. A lot of people will do this, or they'll put a signer on the account, or they'll hire a personal money manager who might come out and assist in writing checks, balancing checkbooks, those sorts of things. So the advantages to doing this, first of all, it's inexpensive. I mean, if you have a trusted person in your life, it doesn't cost anything to do that except your time. It's private. There's no one looking into what's happening. It's between you and the signer or the joint owner on the account. Very easy to establish, one form at the bank. It's a way to potentially avoid probate. We'll talk about that more at the end of the presentation. But if you have a joint owner on your account and you die, the joint owner takes over ownership of the account. It's very convenient, and it can be a simple estate plan, having joint owners on your account. Husband and wife, no kids, that happens quite a bit, where it's just a very, very simple estate plan. Disadvantages, very little accountability. If someone kind of goes rogue as your joint signer, we'll see this usually with children, there's really no one watching what's happening. As a joint owner, they have full authority over that, over those transactions. They can come in and take assets out as they please. It's very easily abused. It's not for medical assistance planning. So if you are spending down your assets to eventually apply for Medicaid or medical assistance, as it's called in Minnesota, and you have a joint owner, it can get on your accounts, it can get very sticky because the state has a 5-year look-back period, and they're going to want to make sure that your assets were spent on you and they weren't gifted out. If they were gifted, they can withhold medical assistance for a certain amount of time, depending on how much money you had gifted. It's subject to liens and bankruptcies, and there can be tax issues. So if your joint owner all of a sudden gets into legal trouble or owes money and now they're an owner on the account, it's possible for those accounts to be invaded. And not to mention, that we've had scenarios with taxes where we've had some issues because the real owner of the account had, who was using it, didn't have their social security number on it. It was the other person, so now they were getting taxed for the income. But again, a very informal, easy way to do things. We'll see this a lot for people who travel. They might have a signer on the account, a loved one that's just a signer, and it's an easy way to do things. So power of attorney. This is, power of attorney is a document where you designate someone as your attorney in fact. It is for finances or estate only in Minnesota. So a lot of times we'll run into scenarios where someone granted a financial power of attorney to a family member, and now that family member comes into the hospital and says, Mom's in the hospital, I need to make medical decisions. That's not what a power of attorney is for. That's a healthcare directive in Minnesota. In some states they'll call it a healthcare power of attorney. But in Minnesota, when we talk about power of attorney, it is for finances only. So you're designating legal authority to another person or entity, and you can make these durable or non-durable. So what that durable means is if you become incapacitated, your power of attorney continues to act on your behalf during your incapacity, whether that could be something where it might be short-term, or there might be a situation where you're in rehabilitative care, or it could be long-term if you have a progressive disease. Non-durable just means if you become incapacitated, the power of attorney at that point should cease to act. And then, if you still need assistance with finances, it's possible that a conservatorship would need to be open. We're going to talk about conservatorship, but we don't see too many non-durable power of attorneys because the whole idea is I'm putting this in place for when I become incapacitated. Where we do see it in place is really two areas. We'll have clients who might travel, and while they're out of the country or they're down south, they might give us a very specific non-durable power of attorney just to handle bills and things up here while they're gone. Or we do have some individuals who have, and I don't think this thinking is wrong, they may not have family members or people close to them, so their idea is, hey, if I become incapacitated, there's no one watching what my power of attorney is doing, so I would prefer they have to go to court and have a conservatorship and have those accounts monitored by court staff and audited. So, a couple of things with the power of attorney. It's very inexpensive. You can pull forms off of the internet and designate your POA if you want to do that. Very easy to do. You need a notary, I think, to get your power of attorney signed in place. The short form power of attorney, it's a Minnesota statutory form. It's recognized by almost every institution. It's protected by Minnesota statute that a financial institution must accept a valid executed POA. Again, very private. There's no court oversight. There's nothing where people are looking at the finances. It's easily revocable. If the person who signed it in the first place still has capacity, it simply just takes a letter. And that's all you need to do revoke a power of attorney. The other thing you can do is limit authority. You can do some very specific things with a power of attorney. You could give someone authority just to handle a real estate transaction, just to pay bills and to take income in. So you don't have to give full authority of your finances to your POA. The disadvantages, it's easily abused. We have quite a few attorneys who will call the POA a license to steal. From our work as a neutral professional, unfortunately, we see a lot of that, where a POA, usually, unfortunately, a family member who maybe got into a bad place for whatever reason starts to, help themselves a little bit too much to the assets, think, we'll see this a lot when asked, well, why did you do that? Well, I was going to inherit it anyhow. Yeah, but your folks still needed the money, so it's kind of a problem. So it can be very easily abused. I mean, you can walk into a financial institution with that power of attorney and clean out, millions of dollars. There's no court supervision. There's no bond. So if there is theft as a power of attorney, there's no bond to protect the person like there is with a conservatorship. It can be very difficult to choose an attorney of fact, especially if you're weighing between your kids. Which one do I choose? And then are you going to get the guilt of, well, you must love Johnny more than me because he's the power of attorney. Or you have my grandparents who I talked out of my mother, who I love dearly, as the attorney of fact. Because I had to come on, Mom can't do this, and Grandma eventually agreed with me. So must have capacity. You have to have capacity to sign one of these, but the capacity is a fairly low threshold to sign a power of attorney. But that, when in doubt, that's where you really want to get an attorney involved. We've even had scenarios where we're looking to avoid a conservatorship, and we'll have the person's physician weigh in the date of signing the POA to cement the fact that they had capacity. And of course, it can be challenged. We'll see this a lot where families, especially if they disagree with who should have been the power of attorney, they'll go to, well, Mom was under undue influence when she was signed this. My sister was living with her and she forced her to do it. May or may not be the case. Usually the truth is somewhere in the middle, of course. But when that happens, then we kind of end up in a conservatorship. Unfortunately, from our standpoint as a kind of neutral professional here, we kind of talk about the fact that a good estate plan is as good as the family dynamics, and if the family dynamics are poor, sometimes these estate plans get blown up. Trusts. We have a couple of different kinds of trusts, a living trust, and which can, is revocable or becomes irrevocable upon death or incapacity. I'll talk about that a little bit. And then we'll touch just very briefly on two kind of specific kinds of trusts, special needs trusts and supplemental needs trusts, which are very specific to individuals with disabilities. But I'll get into that in a few minutes. When we're looking at trusts here, so the idea of the trust is you're creating a new legal entity. You know, it's another person. So while I'm alive, I create my own trust. Everything's still in my Social Security. Any income flows through to me. But when I become incapacitated or I pass away, now those assets in the trust are locked away, are locked into my plan. So if I wanted, you know, if I was concerned about my children now having access to millions of dollars with the trust, I can put it into a place where they get income over a certain period of time, and they get cash at age 25 and 30, and then the rest at 35. You can do things like that with trusts. While you're alive, if you know you become incapacitated, maybe a stroke or something along those lines, you know, the trust is set up so the trustee can continue to pay your cost of care, your bills, those sorts of things. When we look at trusts, you know, you're usually yourself as a trustee. If you have a spouse, the spouse is a successor trustee, and you become each other's successor trustees in the event of incapacity or death. You actually physically move your assets into the trust. So any accounts, any investment accounts, brokerage accounts, outside of tax-deferred accounts like IRAs, you retitle into the trust. Your home, real estate, even businesses, you can put into the trust. And when we talk about the estate plan, you know, we'll talk about why that happens. You're naming the beneficiaries upon your death. And it may be irrevocable. Well, it is irrevocable upon death. It should say may be irrevocable upon incapacity. So again, quite a few advantages. Lifetime management of assets. So this, where you have a trustee, you can put a trustee in place for many, many years to manage a certain amount of assets. Also, there's no gap, like when someone dies and they have a will and they don't have a trust, now we have to probate the will and there's a gap in time before the personal representative gets named. It can access funds to pay final fees, and things can get hung up a little bit there. When the trustee, when the person who has the trust dies, the trust continues. It just turns from revocable to irrevocable, and that trustee can continue to pay bills, manage the assets in the trust, and really nothing changes. It's a good way for financial management, make sure bills are paid, very private, and of course you avoid conservatorship. Again, the disadvantages, you must be competent, so you must have capacity before you can enter into a trust. There's an initial expense. You do want to go to an attorney to draft the trust and and give you advice and help you get everything titled into the trust properly if you want. It may not be suitable for a small estate. It just might not make sense. There's responsibility for new assets. This is an important one. So your whole goal here is to avoid probate. So you've went through, you've changed all your assets, all your real estate into the trust. You've put, payable on death beneficiaries on all of your IRAs, or you've put the trust as the beneficiary, and you shortly before you pass away, you get an inheritance, and now you forgot to put that into the trust and you die. You have to open a probate. We had a really, really bad one. The asset limit to open a probate in Minnesota used to be $50,000. We had a client with many, many financial accounts, and she had everything ready to go into the trust. She passed away. She had one investment account that she inherited from a family member late in life, $52,000. She's $2,000 over the asset limit. We had to go through, probably spent $2,000 opening the estate just so we could follow with what the will said, which was, hey, anything I missed, I want to go into my trust. So again, you have to remember, any new assets need to go into the trust. It's important to understand the tax consequences of a trust and what that might be. And again, depending on how the trust is set up, there's very little accountability to anyone other than the trustee or the person you designate in the trust to receive accountings. But there's other things you can do, like put in trust protectors. So even people who name us trustee may have a family member that they designate as trust protector. That person can have incredible power, like even removing and replacing us with another corporate trustee. So different things to do with the trust. Supplemental needs trust, I'll spend a little bit of time on this one because it's important for a group like this. If you have a son or daughter or grandchild or niece, nephew, neighbor for that matter, who is certified disabled, so that means essentially they're on medical assistance, or they receive SSI, Supplemental Security Income, it is possible to leave money to them in a trust so they can live a fuller life in community. That this kind of trust is available to do things that their government benefits otherwise wouldn't do. So, for example, we have many individuals who their parents were really the person taking them out on the weekend, getting them out of maybe their group home, buying them new furniture, new clothes that they couldn't afford on their $90 a month from Social Security. And now that when the parents know they're going, when they pass, there's not going to be anyone to do that. They leave it into a trust. And we can continue to do those things. So we can pay a caregiver if they don't have family to take them out one-on-one, send them on vacation, pay for dentures instead of getting everything torn out like MA will allow, those sorts of things. A couple rules. With it, the money has to go into the trust. It can't be available to the disabled person directly. They can't be residing in a long-term care facility, and they need to be under the age of 65. The great part about these supplemental needs trusts, not only can you set them up and establish them, you can also then leave a residual beneficiary. So we'll see this a lot where we have a parent who has a child with disabilities and a child or two without, and they know the child with disabilities will likely never spend all the money in the supplemental needs trust. So they'll name their grandkids as the residual beneficiary to that trust. So a really good way to make sure you take care of a loved one with disabilities, but can still leave it to kind of then the next generation of your family. So a couple other rules, the person has to be certified disabled, and essentially that just, the qualification for that is it can be done through the state, and it just means the person basically can't obtain and sustain meaningful employment. We'll see it with developmental disabilities, traumatic brain injuries, might be a physical disability, are kind of the primary. Even mental health, severe mental health issues would allow someone to potentially qualify for a supplemental needs trust. So it cannot be established with the beneficiary's assets. That's important. We see this all the time. If you have a loved one with disabilities and you leave them as or you don't have a will, and you leave them money directly, and then it has to go into a trust, which is called a special needs trust, things change. In the case of a special needs trust, the state is the primary beneficiary. Because if someone's receiving state aid, they're running a bill, they're running a tab. And when that person dies, then they will submit the bill to the trust to get repaid. So it's very important to get these supplemental needs trusts set up ahead of time. So again, special needs trust, I'm not going to spend much time on this, but this is someone who who is certified disabled and is entitled to receive a lump sum payment or a sudden windfall of cash. So it might be a personal injury settlement, it could be that inheritance where it's left to the person directly, they could win the lottery, they could set up a special needs trust, a number of different areas. It can be set up by, besides the person themselves, a parent, grandparent, legal guardian, or the court. Again, the key thing being that the state receives all assets after, or enough to fulfill their debt after the person dies. All right, so conservatorship. This is, you would really never plan for a conservatorship. This is more of a, here's what happens if you don't plan. So conservatorship is the easiest way to think of it, if you're not familiar with it, is basically a court-appointed power of attorney. So it's finances or the estate only. So this is the ability to manage real estate. It can be businesses. It can be paying bills, IRAs, investment accounts, everything. It allows the conservator to sign contracts, do a 2-year look back on contracts that were signed, a number of things. It has to be appointed by the court, and typically the person has to be found to not have the capacity to manage their own financial affairs. There is such thing as a voluntary conservatorship. It does happen in Minnesota. I talked a little bit about a person who might want court to supervise what's happening. Or there's other reasons too. If you did a power of attorney and you're afraid, boy, I might get upset here as I start to lose capacity and fire my power of attorney. We've had people who would do a voluntary conservatorship because only the court can revoke a conservatorship. So we talked a little bit about this. This is what a conservator can do: charges and debts, manage the person's estate, sign contracts, do benefits, help help get a person on Social Security benefits, manage their health care, health insurance, whatever public benefits they might be entitled to. In Minnesota, a conservator also trumps a power of attorney, so they can revoke a power of attorney. They could do set-asides on contracts. We'll use this. This is, I shouldn't say relatively new now, but 15 or 20 years old, this idea of a set-aside. A classic example is we had an individual who signed a long-term lease with a cell phone tower company up in northern Minnesota, and it was the worst lease imaginable for this person. She didn't know what she was signing at the time. So there was a conservatorship filed. We were able to prove she didn't have the capacity to understand that contract, which had happened in the last year, and we were able to get the court to set aside the contract. The nice part about it was we bring that petition to set aside the contract in probate court. So we have a kind of a home court advantage. We're in front of a judge who understands capacity issues. So that's what a set aside is. Sell real estate through a conservatorship. A conservator, from the day they're appointed, they do an inventory of every penny, of all assets, of all real estate, of personal property. They do an annual accounting and a right to restoration hearing. They serve notice that the person under conservatorship has the right to do it. In Minnesota, under conservatorship, the first annual account, every penny is audited, and any account can be fully audited thereafter. It's audited by our court system. Subsequent accounting, second, third, fourth annual accountings are generally spot audited. So the court will say, we want to see these specific documents, and then every fifth and so on is a full audit. Minnesota is actually the only state that requires this or does these statewide audits. There are other states that have a couple counties that might do it, but no one has the oversight that Minnesota has. So a couple advantages we talked about can be voluntary or involuntary. This is the one for the person who didn't do their estate planning, didn't recognize they needed help, and now needs help, and it's an emergency. This is where the court can step in and name a family member or a professional as a conservator. There's court oversight. There's a bond required for all assets $10,000 or more. That's good news, bad news. For an individual to get a $2 million bond, it can be very costly, and the person under conservatorship's assets pay that. It might be, the bond premium might be $18,000 a year on a $2 million bond. And you're essentially ensuring your conservator that they're not going to steal your money. So it's kind of an interesting dynamic. It's a good way to manage complicated affairs. So a classic scenario, we had an individual who actually owned senior care facilities, not in Minnesota, thankfully. I guess there's a couple smaller ones in Minnesota. No estate plan. So when he became incapacitated, he had daughters now fighting over who was running the facilities. And it kind of came to a head when the daughters were both interviewing administrators for one of the nursing homes in separate rooms in the office building, and literally ran into each other and almost started a fist fight in front of the applicants, which I wonder what they were thinking. This is a great work environment. But very complicated. And what ended up happening, First Fiduciary, Dan Lodell, our president, myself as vice president, became president and vice president of those facilities for probably 5 years. The disadvantages is it's expensive and complicated. It's very expensive for it. Outside of if you end up having a professional and paying them, that's one thing. But then, we just had a case that got settled without a conservator. We avoided the conservatorship because we were able to do a power of attorney and some trust work. The attorney fees, again, a very complicated matter where there's businesses and a farm involved. Settled the attorney fees over $500,000 to get this thing settled. And again, it was a scenario where this couple had no estate planning. And there was a fight over, in this case, by people who all meant well, they just had a different idea of who should be in charge. There's no privacy. We file an account with every asset with the court. If my neighbor is under a conservatorship, I could go down to the county and not only see exactly what they're worth, I can see what they spent on health care, where their accounts are, not numbers obviously, and who they're gifting money to. Everything is part of that accounting, and it's very public in Minnesota. We're trying to change that. It can be difficult to find a conservator. Not as difficult to find a conservator as a guardian, but it can be very difficult, especially if it's a smaller estate. And there's ongoing expenses, the audits, the bonds, going into court to get your accountings approved, the attorneys get paid. So again, that's why for the most part, you want to avoid these conservatorships. Rep payee, just very basic. It's a program through Social Security where you don't need a power of attorney. You don't need a conservator. If it's just Social Security, You can actually, Social Security will designate someone to manage someone else's Social Security. Not real applicable here today, but and also some pensions. But where it comes into play is where you may have a loved one who has now spent all their money and all they have left is Social Security and a pension. You don't necessarily have to go through a power of attorney or a conservatorship to manage that bit of money. A lot of times if they're in a nursing home, the nursing home will become rep payee. I'm not going to spend any time on this. Again, very, very limited program. So go into estate planning next, but are there any questions on the management of assets for someone who's still alive? Yes.
You put down, like for trust, small estate, what's the definition of a small estate? I know it's kind of relative.
Well, in small for whether or not you should have a trust, it might not even be value. It might be what kind of accounts do you have. If someone has basically an IRA and no real estate, you probably, it could be a $5 million IRA, but you're going to probably name beneficiaries directly, so you wouldn't do it. Where you really look at a trust is, depending on the amount, what do you want to do with it? If you are gifting it to someone and getting out, right, there really isn't maybe a need to do the trust. But let's say you want nonprofits to end up with a majority of it, and maybe you don't have children, or you have children who might not like that idea. We see this when we're part of estate plans where it's a niece or nephew, and they're coming in, and our client's saying, I'm going to leave my niece a little bit of money, but I want it to go to these charities. I'm a little nervous that's not going to happen if it's my niece taking care of that, because she has no incentive to do it.
Now that's with real property rather than liquid, like cash.
No, even with liquid.
Even with an IRA?
No. If it's an IRA
Or a
and
pension or anything?
or a pension and you're naming beneficiaries,
Or life insurance or anything?
or life insurance, those companies will make sure the proper person gets them. There's a lot of documentation that goes in. It can be frustrating for us as a fiduciary. We'll have someone who's incapacitated, and we try to get it, on behalf of our client, who might be the, deceased son. And as a conservator, they really will make us jump through the hoops to get access.
So large amounts of real estate can be a problem then, is that an area?
Well, especially if it's in multiple states. If you have assets outside of Minnesota and you have a trust, our uniform code in the U.S. allows for me to sell property in Wisconsin without, just through a trust. So I can find an attorney there to handle the trustee work, and that's it. Whereas if you went with a will, you would have to open a probate or an ancillary probate in every single state you had real property.
So people that snowbird a lot, that is kind of...
Yes, exactly. And there's some other ways to avoid, a trust too, that we'll talk about in a minute, but good question. Other questions on managing assets for a person while they're alive? Kind of gruesome sounding. All right, so then estate planning. What kind of planning can you do to make sure the people, the charities, whoever you want to end up with your assets upon your passing get it? So first, foremost, we'll talk about prepaid burial. Very, very easy thing, but a valuable thing to do, especially if you don't have a trust. A will, payable or transferable on death accounts or beneficiary accounts, and then trusts. Kind of the different ways to pass assets. It sounds like maybe you talked about transfer on death deeds a little bit too, which falls under the third one on the previous presenter. So a will is your instructions on what should be done with your property after death. must be mentally capable. I think the language on that has changed. At least 18 years of age. You have to make it without undue influence. It has to be in writing, signed, witnessed, and dated. We see some very unique wills at First Fiduciary. Most are done by an attorney, but we've had handwritten wills that were probated and allowed. So advantages, you decide your funeral, what happens to your possessions, your assets. The disadvantage, you have to make sure that the person knows where it's located. If there's revisions, you have to make sure, those revisions are known, and those are kept together with the original will. The biggest issue, and I don't even have this on here, and shame on me, with the disadvantage is you have to probate the will. Someone has to take the will to court, petition to open the estate. The estate has to be open. There's a period of time where the estate has to stay open so creditors can file claims against your estate. During that time, while you're waiting for the court to probate the will and issue letters, your assets are locked down. So we've had scenarios where individuals have passed away, their family members didn't really have a lot of money, they had no access to the cash, and now they're wondering, well, how do we keep the heat on? Those kind of things. And I tell you, some of our utility companies in Minnesota are not very nice when someone dies during the winter. It's amazing. You're alive. The thinking is just absurd. You're alive and you don't pay your bill. Well, we can't turn it off. You're alive. You're dead. Well, you don't need the heat. Well, the house does. Yeah, hey, we've had frozen pipes because of that very thing. It just, I can't believe it. Slap a lien on the house. You'll be fine. So that's the biggest thing, and there's a cost. It can become very public. If the court decides that they want it to be a supervised will, there's an accounting, there's a final account. All of that can be put in, is part of the court record that, again, anyone can go look at. In Hennepin County, for example, they will, if there are charities named, they will make it the will supervised because they want to make sure the charities get it. So that can get the actual assets. That can slow everything down. So you can create trusts within a will. They're called testamentary trusts. So we'll see a will that says I want all my last expenses paid. And then after everything's paid, I want specific gift here, and everything left I want put into a trust for my son, and then the terms of the trust are right in the will. So that's a very popular way to do this. If you don't, there might not be need to have the trust for your assets while you're alive, but it's a good way to make sure they're protected and they just don't go, they don't pass directly to a person who maybe should have them because of age, addiction, whatever it might be. Payable on death accounts, transfer on death accounts, beneficiaries, these, you own the account during your lifetime and the beneficiary receives upon your death. Great way to leave cash or to leave assets to a loved one, because all it takes is a form and a death certificate to leave those assets to the person. Really important for items like tax-deferred accounts, IRAs, 401ks, those sorts of things, because you can pass along some real tax savings for the person. Let's see. They're very easy to do. Every financial institution has the forms where you name your beneficiaries. And incidentally, you can name a will or a trust as your beneficiary. And when I talk about trust, there's good reason to do that sometimes. There's no probate. So the person who is the beneficiary of the trust doesn't have to wait for probate to open, to get the letters, to give to none of that. Just the death certificate, and they can collect whatever assets are left to them. It's immediate, outside of the will. The disadvantages, we can do vehicles in Minnesota now, so that can go away. You can actually do a transfer on death title for vehicles. But valuables and collections, that can be hard to do with POA, TOD. You really, you're at the I guess the mercy of whoever is going to divide the personal property. So, we will have estate plans that will be very specific to the fact that there's personal property that someone wants to go to someone specific. Uh-oh, I think my slides got out of order a little bit. Oh, cow. There's a lot to do here. Well, let's talk about trusts. I mean, we touched on them briefly, but we'll go back to trusts as I put up types of fiduciary. So again, we spent quite a bit of time on the trusts and what the advantages, disadvantages. But again, the idea with that is to hold assets for a period of time, or to make sure that your wishes are followed through by a specific entity, and to make sure your final bills are paid for. If you leave everything payable on death, we'll have this. God bless attorneys. But I'll sit down with their client and we'll go over the estate plan. And the estate plan will be, I've left all my cash accounts payable on death to my children. Great. The only thing I need you to do is make sure they get their personal property and sell the house. Okay, so you want us to manage the house and divide personal property with no cash? Yes. Well, what about insurance? Oh. What about if we need to pay someone to move items out? Or we decide, hey, if we put in a little bit of carpet or paint, we can sell this house much quicker. What happens if, there's some other kinds of costs? And that's kind of, oh yeah, I should leave a little bit of cash in my, yes, you should. The other thing is some trust companies, and we'll talk about the different kinds. Charles Schwab being, again, I love working with them as an investment company, but as trustee, I've had 3 clients who came in, they were doing a will just because their Charles Schwab trustee or trust wouldn't handle their personal property. So they thought, well, we should open a probate just to disperse my rings, because I want specific people to have the rings. It's like, no, you can do that through a trust. Well, they told me they wouldn't do it. Well, yeah, because they're based, 2,000 miles from here, and they're not going to come into... Well, they'll sell the house. Yes. All 3 ended up naming us trustee after we walked through what that looked like. So kind of interesting. So before I move on to fiduciaries, any questions about the estate planning piece and what that looks like in a different way? Question.
Just in Minnesota, some confusion. We have this new federal estate tax law that can pass on so much money, but that doesn't apply to the state of Minnesota, does it?
No, the state of Minnesota has a smaller exemption.
Can you repeat
Yes,
the
I will
question?
repeat the question. The question was, does the new higher federal exemption for estate taxes apply to Minnesota? And the answer is no. In Minnesota, the exemption's somewhere between 2 and 3 million.
Per person or?
Total on the estate.
Even if you use shelter credit trust somehow in the will anymore or not? Or
the question is, can you use a sheltered credit trust?
AEB we used to call
Yes, that is not a question for me to answer. That's beyond my pay scale. But in general, the way it works is if you die and you have $5 million of assets and it's not in any kind of credit, shelter, trust, the feds will take nothing. You're far under the exemption.
No problem.
Yep.
11, 12 million per person.
Exactly. And the comment 11, 12 million per person. But in Minnesota, they're going to take a look at the assets and what's in Minnesota and how much you have total. And I know it's a little bit more than 2 million, but we'll say 2 million. So if you have $5 million, the first 2 million is exempt. And then they're essentially going to take between 10 and 12% of $3 million as part of the estate tax.
So would a revocable living trust help avoid some of that? Is that one of the reasons for using it then or not?
Would a revocable living trust
That's right.
avoid some of that? No, because that trust is still your assets. So if it's a revocable living trust, your date of death, those assets will be locked in and part of your estate. So they'll look at probate, non-probate, life insurance values. But you know, we're getting higher and higher. I think when I started doing this, the exemption in Minnesota was like 800,000 or
Well, you
750.
because of the lower federal law, you got a credit.
Right.
But planning is a lot different, more confusing now in Minnesota, I think, for this, right?
The comment is planning is a lot more confusing for this now, and yeah, it is. It definitely is. And what we'll see is we'll see a lot of planning for the federal in trust and no mention of the state. So they'll set up a marital trust, for example, to avoid some of the taxes.
For the state.
For the,
So
estate
It's
taxes.
essential to plan differently than we used to.
Correct. It is essential to plan differently than probably you used to. And that's where you get your trust attorney in place to really sit down and go over. But essentially, if you have over $2 million in assets, you want to sit down with the attorney and look at what kind of trust you can put into place to provide some shelter on the estate taxes.
And that includes life insurance policies too.
The question is, does that include life insurance policies? It sure does.
Income tax-free, but not estate tax-free.
Correct. It is income tax-free, but the date of death value of that policy, what it pays out, will be taxed on the estate tax. Yeah. Other questions about the estate planning piece? We're actually doing very well here. So there's a number of types of professional fiduciaries you can name. Trust companies, and sometimes those companies are banks also, but Wells Fargo Trust, U.S. Bank Trust, Security Bank Trust, some littler banks here that on the bank. Though the model for those companies is not only do they serve as trustee, they also invest the money and they make money on investing the money. There's smaller corporate fiduciaries. We're actually kind of a hybrid. We're the only company in Minnesota that actually is registered as both a trust company because of when we were chartered in 1969, and we're also a small corporate fiduciary. But these are individuals like First Fiduciary who don't manage the money directly. So we step into your shoes. So if you're working with your advisor of 30 years, we do the same thing upon your incapacity. Or if you're setting up trusts for minors, we would work with your advisor on those. So it's a little bit different field. And then a private individual who acts as a fiduciary. Could be a family member, could be a professional, could be your attorney, could be your neighbor down the street. We have a pretty interesting case where it was a tailor who wasn't a tailor and then became the trustee of a multi-million-dollar trust. Yikes, that was poor planning. When to use a professional fiduciary? So when do you use someone like me? To avoid conflict of interest between potential trustees and beneficiaries. We see this a lot. Is there the potential if I name my brother to be trustee for another brother who's disabled, and my brother who isn't disabled is the beneficiary of that trust when my brother dies. May he have incentive not to send my disabled brother out on, outings 3 times a week, maybe once a month, he thinks. That you can have that. It's also interesting, and I'm not accusing of any corporate trustees or banks of doing this, but again, they make money on the money. So if all of a sudden they are going to buy a house for their beneficiary, a $500,000 house on a $2 million trust, and put it in the beneficiary's name, they just cut into their profit. So it gets very interesting when we've replaced larger institutions, especially on those special and supplemental needs trusts, where the biggest complaint was, well, they weren't really letting me spend my money. And the first thing you think of is, why? Special and supplemental needs trusts are different. They're meant to be spent on the disabled person. That's the entire nature of those trusts. The possible need or requirement for a co-trustee, where you may have a family member as trustee, but you want the financial institution. Banks will do this a lot as the custodian. They hold the trust funds. Need for investment expertise. So you may want the same person doing both, doing the advising as well as the investing. Long-term multi-generational fiduciary. So this is if you want to leave. You have minor trust set up, or you have a ne'er-do-well family member who, you don't want to give them $50,000 at a crack, but you give them $5,000 a month and they're going to be okay. It can create family strife. I've got all kinds of fun families. I have a very wouldn't necessarily be called dysfunctional family, but my grandmother felt very awful. My oldest uncle was involved in a hunting accident and has his own supplemental needs trust. And my grandmother would not remove him as trustee because, well, he's my oldest son and he would feel hurt. And I said, well, Grandma, when you go to sell your house, the trustee usually needs to kind of know the condition of the house. Yeah, well, he can't get in your house. Oh, I suppose that's a little bit of a problem. I said, yes, it is. And not to mention, he needs someone to manage his own money. So that was really traumatic for her to remove him, but eventually she did. And then need for tax expertise. When you're looking at your estate creates a family trust and a marital trust. So there is some kind of tax shelter for state tax purposes. Those are the areas you may use a professional fiduciary. The one that I didn't put up here, but happens so many times, is the family trustee mismanaged the funds, or sometimes professional, frankly. A couple others. Wow. Why would you ever not use a professional fiduciary when I see all these reasons? I'm just kidding. There's plenty of reasons. Need to invest significant time in acting as a fiduciary. This can be really tough. I think of our clients with mental health issues where we are going to be trustee and we are spending 10, 20, 30 hours a month trying to keep them on benefits, get them help, just a system where we've had, large companies in trust that a family member just wouldn't have the time for. Skill in administration, I think that's kind of, goes without saying. Duty of confidentiality, that can be kind of tough on family members. Possible savings in outside legal, CPA, or investment advisor fees, and to protect the estate from possible fraud. Whoa, allocation of assets. I don't know if I put that one in there. Finding a fiduciary, so there's a couple of places you can look for. Minnesota Association for Guardian Conservatorship, NGA, referrals from attorneys and other professionals, advertising, internet search, talk to your financial advisors. They usually have trust companies that they like to work with. All good ways to find someone. When you look at, how do I select someone to do this? If you're looking at a small or corporate fiduciary who isn't a bank or trust company, ask them about their licensure, certification, what kind of background do your staff have to do this? There is no license or certification requirement in the state of Minnesota. That's what makes this a really important question. You can look at MinSys, this is a court website, to see how many court supervised trusts they have. Have they ever been removed as trustee? Do they have any civil actions against them? That sort of thing. It gets references. What kind of minimum requirements do they do? A lot of times an individual or small corporate fiduciary will take on smaller ones. We met with a Wells Fargo advisor yesterday. He said their minimums are now 2.5 million. So not everyone has 2.5 million, but may want a trust. Make sure you have, your interview points ready to go. What kind of, who am I working? How do I access my trustee? What does the relationship look like? And then, you may want to cross-check the information received. Corporate or bank fiduciary, again, reference from other beneficiaries, attorneys, colleagues, your advisor, great people to talk to about these. And then, again, when you talk to the trust, some of the questions, how long have you been here? How long do your staff come here? That, have been here. That, when we take over for a bank, that's the biggest complaint we hear. Is, oh, my first trust officer was great, and that was 3 years. And now we're 10 years in and I'm on my 4th trust officer because big bank, US bank, people get promoted. I mean, they do a great job and off they go. We kind of joke, if you've had the same trust officer for a while, you might wonder what's wrong with them because they haven't been promoted out of that position yet. Acting as a professional fiduciary, this is just kind of, I kind of like to talk about this more in conjunction with some of our other work, like care management and guardian conservatorship. But one of the things when you're working with a professional fiduciary like us, what does that relationship look like? We go out, we visit our clients. My staff's background, for example, is we've got 5 individuals who have their master's in gerontology. We have licensed clinical social workers. We have 3 individuals who were from banks, 2 individuals whose background was mental health. So kind of the relationship we have with our clients is again, that substitute decision-making relation, stepping into their shoes when they lack the capacity to do so, to make the decisions they would. A couple of things when looking at professional fiduciaries, what kind of insurance do they have? Are they bonded? This is a nice, frankly, the biggest advantage to banks. They're self-insured. Most have $1 million self-insurance on each one. There's no additional payment, those kind of things, because they're so large and they have their own assets. A lot of this goes kind of into the nuances of conservatorship, and I don't know if it's appropriate today. A couple of things though to talk about here. We talked about 2-year look back. So arranging for insurance and prepaid burial for clients. This is something that fiduciary can help you do, so you have things set aside. And then, do they have a comprehensive understanding of benefits? If you name your power of attorney, are they able to help you through, Medicare supplement plans, making decisions regarding Part D, those sorts of things? Another area when you're working with a professional fiduciaries understanding kind of their principles in ethical decision-making, substitute judgment versus best interest, their understanding of decision-making capacity, being objective and setting aside their own values. For example, we do require our staff to go through certification through the Center for Guardianship Certification. The whole idea is we're training our staff to set aside their own values, step into our clients' shoes, and make decisions that they would make if they had the capacity to do so. Again, that idea of being objective. We talk more and more about dignity of risk, and when we're working with our clients who have incapacity, making sure they're spending their money on things that make sense and they would want to do, even if it isn't the safest thing to do. We walk into almost every client relationship we have expecting the goal of that person to stay in their own home as long as possible until they tell us they don't want to. Regardless, that may be a drain on assets. I think we're First Fiduciary when we've worked and we've had to remove, if you will, a person's financial advisor as trustee or power of attorney. More times than not, it rarely happens, but once, maybe twice a year, we'll have an advisor who is saying, well, it's costing a lot of money to keep them in their home. And we're looking at the account saying, well, of course it is. They have the assets to do it. They have the want, the need to stay there. And when we look at life expectancy and quality of life, it makes more sense to spend the money doing that. That sometimes can rile up the advisor who's paid on commissions. But again, very, very rare. We're fortunate to work with so many great advisors here in Minnesota, frankly. So, different strategies, family involvement. Where do you put your family? Are they there? Are they going to be the ones who are actually serving as trustee, or are they the trust protector? Are they the ones who get the accounting from the POA? Is a company like First Fiduciary secondary to them in case they can't handle it or they're too busy because now they've just started their family? And these other things have more to do with the protecting of the person. I don't know where we're at with time, so we went over assets. That's kind of my talk today, is to talk about handling assets and estate planning. Like I said, there is information in here on kind of the same thing, the estate planning, but for your person. Who makes medical decisions? Who makes burial decisions? Who makes decisions where you live in your incapacity? So that is part of the packet there. But otherwise, I don't know if you want to take a break, and I'll stick around for questions. Does that work? Or is there any questions for the general audience?
All right, let's thank.
Thank you.